All right.
All right. Good evening, ladies and gentlemen. Today is February the 28th. It is now 6:47, and we are going to begin our Housing and Real Property Subcommittee. I am Marvin Holmes, Chair of the subcommittee, and we do have a quorum. Therefore, we will get started. The order of the bills that we're going to discuss is we're going to start with 697, 503, 699, 486, 285, 926. And then we're going to jump down to 853. And the last one we're going to discuss is 477. All righty, that's 8 bills. And I will direct you through these as we move through each of them. Starting at the first bill, which is HB 697. HB 697 is a piece of legislation, ladies and gentlemen, that is relevant to obtaining title in a commercial transaction only. This is not relevant to residential. It is only for commercial transactions. And in a nutshell, what the bill does is that it allows the buyer to be able to use the title company that they would like to in a commercial transaction, much like a residential transaction. And Ben, if you could please, sir, uh, give a more in-depth legal description of the legislation and discuss any amendments that we may have. Then you have the floor.
Okay, thank you, Mr. Chair. Okay, everyone, so HB 697, as the chair gave a good overview of, the sponsor is favorable. The cross file is SB 1169 with Senator Hershey. There's no fiscal impact. And more specifically, what the bill does is extend protections that are in residential real estate contracts to commercial contracts. The bill provides notice in commercial transactions that a buyer has the right to select the buyer's own title insurance company, settlement company, escrow, and title. The testimony we have is favorable from Maryland Chamber of Commerce and the Maryland Building Industry Association. And then there's also unfavorable testimony from the Maryland State Bar Association's Real Property Section. The sponsor's position in light of the testimony that was submitted unfavorable was that the objection is based on keeping referral fees. That's typically something that the seller gets a benefit from receiving by selecting their own title lawyer, title insurance, those type of things. And Chair Holmes, I can pull up the bill and show the testimony from MSBA's.
That would be great. Let's look at the bill first, and then Ben, after we look at the bill, I'd like for us to discuss the unfavorable report.
Okay, can everyone see the bill and the
Yes, we see the bill on the right-hand side, yes.
Okay, great. So yeah, as I mentioned at the outset of this, on the left-hand side, we have 17524. That's the residential real estate transaction provision. And for use in the single-family dwelling shall contain, in boldface type, a statement that the buyer has the right to select the buyer's own title insurance, settlement company, escrow company, mortgage lender, and title lawyer. This HB 697 is modeled after that. But of course, as I mentioned, it's for commercial real estate transactions. I was able to speak with the advocate with the MSBA's Real Property Section to get a little more information. and here's their testimony, and then they drafted a conceptual amendment. So they noted that with residential contracts, there's a federal requirement to let the buyer be able to make choices about title. And there are penalties if the broker is not providing that notice or permitting the buyer to make those selections. So that's why we have that provision for residential contracts. And then for HB 697 here, it's the same language that we went over to address the amendment specifically from the MSBA's office. The C in their testimony was that the failure to include the statement under subsection B of the bill shall not affect the validity or enforceability of the contract or subject any person to any penalty. In a lot of ways, that would remove the force and effect of the provision for subsection B in the current bill, HB 697 that we have. That is based in part off of the existing residential contract provision, where it says a contract is not invalid by the omission of the statement to the buyer under subsections A and B, except you see, if you take a closer look though, there's also language added here that or subject any person to any penalty. And so I think that was added because if you take out the penalty language, then the bill really has no force and effect. That would mean brokers can violate the provision of the bill, which would be not providing the statement that the buyer can pick their own title insurance. And if that's happening, then there won't be any penalties for the broker for violating the law. So if you like the bill, it would seem reasonable that you would want the bill to be enforceable in the same way that the residential contract language is enforced. And then there's a subsection D, which is somewhat similar. It says the inclusion of the statement required in subsection B shall not prohibit the parties from negotiating any term of the contract. And then that's already sort of part of the bill, because subsection B of the bill, again, is just that a notice that the buyer has the right to select their own title insurance company. So so it's just the right. It's not mandating that they get to pick their own title insurance company. It's just a statement that the buyer can select their own, of course. And that this operates the same way that the residential language is. So the parties through contract want to contract it out and make those decisions. That's up to them.
Thanks, Ben. In my opinion, is that the way the bill is written now, 697, which mirrors the residential contract, would seem to me to be the way that we should move forward. I'd like to have another piece of discussion, if we may, about what's the status of the cross-file, Ben, SB 1169. Has the Senate taken it up yet? It's got a high number, so it's probably not on their radar at this particular time. And while Ben, go ahead, Ben.
Yeah, thank you, Chair. That's in rules right now, but
Okay.
yeah, I guess it would probably, if that's the case, depending on what the subcommittee does, the outcome of that one would be based on this one.
Right. Thanks, Ben. And like I said, ladies and gentlemen, I think that we should move the bill as written without the suggestions from the opposing the organization that is in opposition of the bill. That would be my suggestion, ladies and gentlemen. Can I get a motion and a second, then we can just discuss it further?
I'll make a motion favorable without the amendment.
There's a motion. Go ahead, have a second, please. Second by Ann Healy. Discussion period now. We have a motion favorable and we have a second. Any discussion on HB 697? I see Delegate Baker's hand is up.
This is a motion to move the bill, correct?
Yes, that's correct.
So who is in opposition?
Opposition is, just as we discussed a couple minutes ago, is the bar associate, There you go. The Maryland State Bar Association.
Okay. Thank you.
Yes,
And
sir.
if I may, Chair Holmes.
Yes, sir.
Okay, sorry. Yeah, I was a little mixed up by this too. I think for what it's worth, it's the real property section as opposed to the entire Maryland State Bar Association. But
Delegate Lehman.
Yeah, I was going to ask the same question because I didn't see the top of this, but can someone remind me, did they actually testify?
I remember the realtors came in to testify.
Yeah, I don't remember them being present, but maybe, I don't know. Every day is just rolling into the next day, and I keep thinking today is Thursday and it's Wednesday, so I'm not a good judge. But does anyone, Ben, do you know, did they come in person? I don't remember hearing about this, their view of this. That's fine. I'm just curious.
You're on
I'm
mute,
just
Ben.
curious.
You're on mute, Ben.
That's all, Mr. Chair. Thank you.
Okay.
I'm not seeing that in my notes, but I couldn't be sure right now.
Yeah. Delegate Baker next. Oh, I'm sorry. Delegate Baker, you got your hand down. Delegate Allen. Uh-oh. You there? Nick? Delegate Allen? Can everyone hear me?
I can hear you.
Can you hear me?
Yes, okay. Yeah, you
Okay,
have the
that
floor,
was
sir.
weird. No, I just want to add. I noticed like the
Uh-oh. Uh-oh. All I hear on your side, Delegate Allen, is a hum. Is it me? Can everyone hear me okay?
I can hear
Yes.
you, but I can't hear, I hear the hum also.
Delegate Allen, can you speak to let's see if we have a good connection here? No. Delegate Allen.
There could be an issue with the
Uh-oh.
people on the call, but
Okay. We're obviously having technical difficulties here.
How about now?
Yes, sir. There you go. Take it away, Delegate Allen. You have the floor.
Thank you, sir. I know. I just wanted to just mention because we were talking about who was in favor, who wasn't.
Now you went silent on us again, Delegate Allen. Oh my goodness. I'm not Delegate Allen, you
I think they might be trying to rejoin, Chair Holmes.
okay. All right. Okay, so this is what we're going to do, ladies and gentlemen. We have a motion and a second on the favorable. And I'm hopeful that Delegate Allen can get back on as soon as possible. I hate to hold up progress here on this legislation, but
He's in the waiting room, Delegate.
say again?
He's in the waiting room. I'm admitting him now.
Oh, thank you so much. Where is he?
I'm back, Mr. Chair. Can you hear me?
Yes, much better. Thank you, Delegate Allen. You have the floor.
No, I give up. It's fine.
Thank you very much. We have a motion favorable, and we have a second. Any additional discussion on HB 697? Hearing none, all in favor of HB 697 indicate by saying aye.
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 Any opposition on HB 697? Does anyone need to excuse themselves because of the rule? Hearing none, HB 697 will receive a favorable report without amendments from the Housing and Real Property Subcommittee. We will now go to HB 503. HB 503, ladies and gentlemen, is a bill that is relevant to corrugated stainless steel tubing, CSST. And if you recall from the testimony, this bill is an attempt to set some priorities in terms of the type of tubing that can be used to increase the ability to not to have lightning strikes or surges in electric to cause fires. There was significant discussion on HB 503, and there was a lot of testimony on HB 503 as well. I'm sure most of you remember a lot of the testimony that took place here. And there's a lot of testimony for and against on this bill. And we also have some amendments. So what I'd like for you to do, Ben, is first off, talk about the bill in its initial format very briefly, and then go to the amendments. Ladies and gentlemen, the amendments that we're going to be discussing are the amendments that were put forward by the sponsor of the bill in an attempt to address some of the unfavorable unfavorable testimony and from some of the amendments as well. So Ben, briefly about the bill, and then go to the bless you, Ann, and then
I'm
go to the amendments, Ben.
Okay, thanks, Mr. Chair. So most people probably remember from the bill hearing, there's a lot of testimony about the impact this had on firefighters and the risk of fire hazards at people's homes during lightning strikes. So it's probably a good general overview. The bill is regulating the use of corrugated stainless steel tubing in housing. And the sponsor is favorable with amendment. There's no fiscal impact. It's cross-filed with Senator Brooks. The testimony is all favorable. There was one unfavorable from Omega Flex, which I believe is a manufacturer of corrugated stainless steel tubing. And then there, let's see. So that's kind of a good overview, Chair Holmes. Did you want me to pull up the amendment? Or?
Yes, let's talk now about the amendments to the bill. And what the amendments are attempting to do is address the some of the concerns about some of the unfavorable reports. Bring up the amendments if you would, Ben.
Okay, so this is the reprint, and we can go through it. Everyone was emailed a copy of that this afternoon. So the main difference in the bill that was drafted, and that's in the system online, and then this one is the modification of the standard or the requirements or the criteria that's used or expected for corrugated stainless steel tubing that's in use. So let's see. It starts, we have the prohibition here about corrugated stainless steel tubing that is sold, offered for sale, transferred, distributed, or installed in the state shall comply with the most recent edition of the International Code Council Evaluation Service, PMG listing criteria, LC 1027, and that's a technical code standard that is used in occasion in COMAR or in the code with plumbing and those types of like building ordinances, those types of things. But because of concern or dispute over the specific standard, and we can certainly go over that too. There's also a second requirement or option in A2 for the criteria determined and approved by the Secretary of Labor to be equivalent to or more stringent than the most recent edition of the LC.
And Ben, I'm going to pause you there for a minute, because this is the area, ladies and gentlemen, where there is most concern by the opposition of this particular piece of legislation. The opposition to the legislation is saying that there is no 1020 LC 1027 standard. However, there is, however, a listing criteria for the LC 1027. And what the sponsor of the bill did was he put that or section in there so that the or section would then allow a portion, would then allow the Secretary of Labor to make the decision if one of those two criteria were not met. I will say that this testing criteria has been used elsewhere, and it does in fact take the reduce the amount of fires that have taken place. I see a couple of hands up. I'm going to start with Delegate Allen first. Nick. Are you say something now, Allen? Delegate Allen? No, dadgummit. Let me go to Delegate Naraki and then Delegate Allen, see if you can figure out what's going on. Delegate Naraki?
Yes, sir. I'm here, Mr. Chair.
Yes,
Can you hear
go
me?
ahead. Yes, sir.
All right, we're working. Mr. Chair, with this, or maybe this is a question for Ben. I was particularly interested in what the builders said about this. Would this particular amendment address the concern of potentially creating a monopoly? Because I'm very concerned about the idea of having these fires, but I also don't want to create one company that's the only one out there to supply this piping. So would that address that concern, this part here?
Well, this is, keep in mind now that I did see that, and I want Ben to chime in here afterwards. Like every other testing criteria in every other kind of building material, this is referencing a testing criteria. So anyone can make a product based upon this testing criteria. So it's not, it doesn't prohibit anyone from making it. Ben, if you could expand upon that, I'd appreciate it.
Yeah, thanks, Chair Holmes. That was right. So yeah, and I appreciate the question too. LC 1027, there's lots of the International Code Council produces many different standards and criteria and requirements. Companies can create products that adhere to that, but it's not the case, in my understanding, that companies are patenting LC 1027. And furthermore, part of the amendments from where the bill started on the left to the bill is amended on the right of the screen, there's also that alternative option, which is criteria determined and approved by the Secretary of Labor. So that if A1 isn't going to work for people, then it would be A2 as an alternative.
And Mr. Chair, may I ask a follow-up to that?
Yes, sir, definitely. You have the floor, Delegate Naraki.
Thank you, sir. Would then, or I should say, are there other companies? There's one particular that's referenced in that letter. Do we know if there are other companies in this space that are making products that may meet this criteria? Then maybe that's a better way to phrase that question.
I'm not aware. Ben, have you been notified of anyone else?
I'm not aware of any specific companies, but my understanding is that there's many manufacturers out there. There's the current standard that is proposed in the bill, and the ICC or the LC 1027 is also a public document, and in theory would be one that could be a product could be created for.
Okay. Thank you, Mr. Chair.
Certainly. Delegate Allen, have you rejoined us? Do me a favor, Ben, if you would, please, sir, continue with the bill in terms of amendments. I'm trying to give Delegate Allen an opportunity to rejoin us.
Okay, great. Thanks, Jerome. So that's the first provision, 19107 in the business regulation, again, about selling, offering for sale, transferring, installing corrugated stainless steel tubing that doesn't meet that requirement. Then there's this existing provision of the bill. This is for the use specifically in buildings, and it's amending It's amending the bill as drafted, specifically to say that only corrugated stainless steel tubing that complies with 19107A, which is the standard we were just discussing, may be used in new construction, gas piping, and renovated property if the renovation is 50% of the total square footage of the property, or a natural gas or liquefied propane piping system.
And let me do this. Let's pause here for a minute, Ben, if you don't mind. Delegate Allen, if you are still online and cannot speak, if you could post your question in the chat, perhaps we can address your issue that way. But I wanted to give Delegate Allen an opportunity to do that. Please continue, Ben.
Yeah, so that's pretty much the bill, Chair Holmes. Again, most of it centers around at the beginning with the bill, with the standard being used. You know, the concern was that LC 1027 is not a standard, or that it wasn't in the International Fuel and Gas Code. That's been removed, as you can see. There was concern about the patenting, but then A2 was added. And the discussion we had about other companies being able to have products that adhere or create that are conform to the LC 1027. It has been used in other jurisdictions.
Expand upon that if you would, Ben. This has been used in other jurisdictions. Expand upon that for a minute, and then I'm going to get to the questions. I'm going to go with Delegate Healy first, and then Delegate Boyce after Ben's explanation.
Yeah. So one jurisdiction that used this in the past was the city of Lubbock, Texas. They didn't have. They weren't able to actually codify the language because of a lawsuit that was enacted, and then there was subsequent legislation that preempted the use of international codes in general. That's my understanding of the outcome of that. So the case wasn't decided on the merits, but the language was used in a city ordinance that, you know, was enacted or proposed, but then it was subject to subsequent litigation, and that was the outcome.
All right, great. Let me do this. I'm being advised that Delegate Boyce had her hand up first. Let me go to Delegate Boyce first, and then to Delegate Healy. Delegate Boyce, you have the floor.
Thank you, Mr. Chair. I want to and thank you for the clarification of this, because I know in during the hearing there was a lot talking about standards versus non-standards. So I'm glad this cleans up. But I guess my question, and it may be hypothetical, and you can cut me down if it is. So what happens after October 4th when this goes into effect? If I'm a retailer per se that sells this particular product, but I have the other version, and I'm not even getting to the LCs or whatever, I have the other version versus this current version. Do I can't use it, I throw it away, I'm not reimbursed for it, it's dead. They just have to start buying this new product.
Well, the scroll back up to the amendment. The Secretary still has the opportunity. Let me read this. The Secretary still has the opportunity to allow this. However, they still have taken into account the LC 1027 standard. Give us some clarification on that, in your opinion, Ben, in terms of Delegate Boyce's question.
Yep. So yeah, the concern, I guess, is about the use of the tubing and the effect it has in housing. So if it's not compatible with the standard, the goal would be to prohibit it being used. And the understanding that I have from working with some of the advocates and discussing the bill was that it's the main use for corrugated stainless steel tubing is just for housing, and for propane tubing within that.
Okay. And just for a point of clarification in terms of the process we're in now, we do not have a motion on the floor, and that's on purpose, because I want to have additional discussions in case we need to do something different at this present time. Delegate Healy, I'm sorry, Delegate Boyce, have you finished your question?
Not really, but I'll figure it out. Thank you so much.
Okay. I didn't want to cut you off, Delegate Boyce. Delegate Healy? You're on mute.
You all muted me. That's okay. I don't want to step on anybody's toes or anything. I'm really kind of at a loss with this. I mean, I have not been able to pay as much attention to these things as I wanted to. So I have a couple of like questions. This whole thing about it being meeting a rating but not a standard. I mean, how can you have I don't understand what that means. I mean, it seems like it has to be a standard because I mean, that's all we can measure is against is this is what if it meets the standard or it doesn't. I don't understand why we have this distinction. That's my most important question.
Okay. Ben, you want to start the discussion there because we can and then we'll expand upon it after.
Yeah.
Because there are two different types. There's a testing criteria and then there's a standard. So Ben, if you could expand upon that, and then we'll have additional discussions.
Yeah, thank you, Mr. Chair. My understanding is that the LC 1027 is a listing criteria, and what that means is the corrugated stainless steel tubing is subject to a variety of tests, different, that's, in essence, that's what that is. And then within that, the type of corrugated stainless steel tubing is required to stand up to or withstand various different tests. So, we can call it, you could call it a standard. I can pull up the LC 1027 and where they talk about how they have, things like the exterior jacket system.
I don't think we need to go into that detail.
No, that was my first question. The second question was about I got some testimony delivered to me from the city of Frederick today, and I didn't want to, and I wanted to. I understand the issues about lightning and all of that we want to make sure everything is safe. The objections of the builders, do these amendments take care of that so that we can have a safe product and still make it useful to the industry?
Can you pull the builder's testimony up, Ben? Thank you, sir.
Yeah.
Then we're going to go to you, Delegate Naraki, as soon as we get finished with Delegate Healy. And expand that a little bit, Ben.
Okay, great. So in the MBIA's testimony, they say revolves around whether it matters that all equipment and piping systems installed within Maryland homes have a national consensus standard, or be allowed based only on what is called listing criteria. Listing criteria is intended for emerging products that are not currently covered by a national consensus standard. The biggest difference between a consensus and listing criteria is the development process. Listing criteria can be developed by an organization other than a SDO, and ICC Evaluation Service is a non-SDO. So the listing criteria, and then they go on to discussing about how the CSST tubing is manufactured specifically for non-arc resistant CSST design, which refers to lightning strikes, I believe. And yeah.
This is what we're going to do, ladies and gentlemen. I'm going to take Delegate Naraki's question and any other questions that we may have on HB 503, and then we're going to hold it for additional discussion at another meeting. But
Yeah, if I could just ask if there's a representative from the builders that's on the meeting, if they could meet me offline and at some point and talk to me about their concerns, because I need to understand this a little better.
I understand. And I think a lot of us on the call now have the same concern that you do, Delegate Healy.
Thank you.
Which is why I made that suggestion. Delegate Naraki, you have the floor, sir.
Thank you, Mr. Chair. I appreciate it. when we started talking about the secretary's office, it kind of jogged a question in my mind that I wasn't sure. Have we checked with the Department of Labor or the secretary's office to see if they're capable of making these determinations? I just don't want to put something to them that they're not capable of doing.
That's a very good point. I, as the chair, have not, I have not asked the sponsor of the bill if they have either. Are you aware of being either way, whether communication with the secretary has been made?
I'm not aware of specific discussions with them, but the Department of Labor does do a bunch of regulation of tubing, is my understanding, and corrugated stainless steel tubing. So
Okay.
that was sort of the
Absolutely.
basis for that.
And that makes sense. It would be nice to know if specifically they're able to do it with this, specific type of tubing or this specific type of product, because it seems to be complicated, at least for me. It's complicated.
Thank you, sir. Delegate Boyce?
Thank you, Mr. Chair. To Delegate Healy's point, is there someone on the call from the industry that can just briefly speak to this or no?
Hang
Do
on
we
a
know?
second. Hang on a second. Let's check. Is there someone on the let me see here, from Building Industry Association that is here? I'm scrolling through.
And someone has pinned Naraki. Can they unpin him?
I think Aaron Greenfield.
Yes, sir. I am not from MBIA. I'm sure I could make some things up that might satisfy you guys, but
No,
I
we don't
think
want you
I'm the
making
right.
anything up. Nope.
All right. Fair enough.
All
I
right.
thought Bob Anton was supposed to be on, but I don't see him.
Well, that's fine. It would have been nice to be here just to check in, but thank you.
I think what we're going to do, ladies and gentlemen, in light of all these questions, I want to make sure we're making accurate decisions. Let's hold HB 503 until next week. Is that okay with everyone? Great, glad to hear it. All right. Let us now, ladies and gentlemen, go to HB 699. HB 699. Let me turn to my folder here. HB 699 is a bill in reference to graffiti and hate crimes. And if you remember the discussion was relevant to the removal of graffiti and the time frame that was being discussed in the bill for removal of the graffiti. And ladies and gentlemen, we have had some additional discussions in terms of this time frame, and there is still some concerns relevant to the time frames that were discussed in this bill. We probably need to hold this one to make sure that the timeframes can in fact be met. Ben, can you expand upon the bill and the timeframes in the language of the legislation, please?
Yep, thanks, Mr. Chair. Should I go over it too real quick, or is it?
Say again?
Would you like me to go over the bill?
Yeah, please, yes.
So the sponsor is favorable with amendment. Two amendments were sent out. The cross file is SB 650 with Senator Kagan. There's no fiscal impact. And then this is the bill. I have the amendments up to Chair Holmes.
Sure. Put
Okay.
those up.
So yeah, there's two amendments in no particular order. The amendment on the left, this is again, as people may recall, it concerns insignias or symbols that are placed on real or personal property. And then within that, requirements for the removal. So on the left here, you can see that except as provided. So there's the requirement that the graffiti be removed. And then, however, the tolling time or the time to address that is addressed in D1. So it says that except as provided in D1, it says except as provided in paragraph 2 of this subsection within 24 hours after an alleged violation of 10.305.1 in the criminal law article is reported to a law enforcement agency by the owner of the real or personal property, or within 24 hours after the owner of the real or personal property receives notice from the law enforcement officer in subsection C, the owner of the real or personal property shall remove the item or symbol from the real or personal property. So that was done because of concerns about timing and it being unclear which 24-hour timeline needs to be followed.
Thank you, Ben. Delegate Boyce?
I think I moved a little too soon, but yes, I was going to address the quote unquote timeline because there were some statements made during the hearing that, with all due respect, I know it is important to get this stuff down, but it wasn't realistic into how folks could quickly get it down, even if you're a quote unquote high-rise facility, so on and so forth. So, I have just a couple of thoughts about, rather than 24 hours, yes, you need to remove it, but maybe there's some type of acknowledgement type of procedure where, it's noted, it's acknowledged, you have it down, and then you have, 3 to 5 days to get rid of it. Because I mean, realistically, absolutely, not even 24 hours, you want it gone in an hour, but I don't know how big it is. You're in urban places like Baltimore City. I've seen graffiti in places that would require literally a helicopter to get to. So it is important because we don't want this stuff up, because once it's up, then it influences other people who have these same views to do more. And so, but we do need to be realistic about how we do this. And I think there may be ways it may not be to the agreement of the sponsor.
And that is exactly the concern, Delegate Boyce. I hadn't thought about the helicopter scenario because I haven't been in a helicopter in a while, but that is the concern in terms of the time frame, and depending upon where, in fact, the graffiti is located. Delegate Naraka, you have the floor, sir.
Thank you, Mr. Chair. I appreciate it. I absolutely agree with the spirit of this legislation. I mean, I'm someone of Jewish heritage, so I agree with the spirit of where this law is going, but I do have some questions. One of the questions is, what if we can't get, or what if we can't get in touch with the owner? So I've discovered here recently, in my district, we've got a bunch of mobile home parks. There's some folks that do all kinds of interesting things with LLCs, out-of-state LLCs and things like that. What happens in a scenario like that where you can't really track down an owner? So that's question one. I don't know, Ben, if you have any thoughts about, that scenario.
That is a real good concern, Delegate Naraki, because if we can't get in touch with the owner, then who in fact is going to take the risk in removing that graffiti, because that would in fact be a risk in terms of quote unquote damaging personal property.
Right.
You follow what I'm saying?
Yes, sir.
I think we'll have to have additional discussions on this, which is why I said at the beginning, I wanted to discuss this one, but we're going to hold this one for additional discussions. And what I'm asking all of us to do on this bill and the previous one, to get your amendments put together or your thoughts put together on these bills, because we want to get these out as fast as possible. I don't want to get them out irresponsibly. So if you have suggestions or amendments, please put them together so we can move forward on this legislation. Yes, sir, Delegate Naraki.
Just one more, Mr. Chair. So my other question is, how does this apply to public property? I'll give you an example. So in my district, I have Amtrak bridges in my property. In our district, I'm sorry, I've been asking Amtrak for 2 years to take graffiti, in some cases offensive, maybe not hate crime like graffiti, but offensive graffiti off of these bridges, and I cannot get them to do anything with that graffiti. So I'm just curious how that would apply to public property like that.
Great question. Great question. And I have no idea. As I was coming in here a couple of days ago, I saw something on a CSX facility, and trying to get in touch with the train stations. I'm sure we all is virtually impossible. Delegate Naraki, any additional questions or statements?
No, sir. Thank you.
Delegate Lehman?
Yeah, thank you, Mr. Chair. Now, I think Vice Chair Boyce made some excellent observations, as did Delegate Naraki. I have to say, I'm not sure I could, I'm being really honest, I'm 100% in support of the spirit of this, but I don't know how we, amend this to make it realistically effective. Another concern of mine is the wording about, so it talks about how, once a law enforcement agency has been alerted, then they have to, the law enforcement agency has to, quote unquote, promptly notify the owner. That's not spelled out what promptly is that is within a day or two. Maybe it takes a while for the law enforcement agency to act or make that connection. And then that 24 hours kicks in. The whole thing is just not, I don't see how it's even enforceable, to be honest. I mean, understanding the intent and the spirit of it, especially when it comes to these very disturbing, hate symbols. But again, to Delegate Rocky's point, you might not be able to find the responsible party. And to Delegate Boyce's point, these things aren't always in simple places. Think of one of the most infamous spots, and I don't mean to compare apples and oranges, but I think, because I just passed by the spot on the Capitol Beltway near the Mormon Temple where there's that Surrender Dorothy, that famous, graffiti on that bridge. Places where people do stuff like this are not always easy to get to. It's not a matter of just putting up a ladder and scrubbing it off. So I'm just being really candid. I don't know how this can be fixed. I will think on it, but I can't come up with a way in my mind how we could get at this in a way that makes it enforceable. Thank you.
Thank you, Delegate Lehman. That's exactly why we're having this discussion, ladies and gentlemen. Delegate Healy, you have the floor.
Okay, thank you very much. The only thing I can think of that might be adaptable to an enforcement mechanism for this would be like you have for some kind of code enforcement. If somebody's home is cited by code enforcement because they haven't, they let the paint deteriorate, or the grass grows is too long, and the municipality says, if you don't, they give them more time than this, but if you don't get it done by a certain time, then we're going to send in the city with lawnmowers and we'll add it to your tax bill. I mean, there might be a way to do that where you could have a government entity say you have so much time to cover it up yourself. I don't know if you can always erase it. You might have to cover it with something so that it's not visible, because it might take more than a day or two to get that stuff completely off. But I don't think that's the intent. I think the intent is so that you can't see the offensive part, to hide that from view. And if you don't do that within a reasonable length of time, and I don't know, we're going to have to talk about that some more, then maybe we can have a government agency come in and say, we'll do it for you, and then we'll just charge
local code enforcement agency or that, or something along those lines. And maybe it's not, and maybe I'm going down the wrong track here, but I just wanted to throw that out for discussion potentially.
There potentially could be, in light of that, if it was in a pretty accessible location, and as I indicated at the beginning, these discussions, as we move forward, if anyone has additional language that they want to add to these legislation, please do so we can move these bills along if you have suggestions. Delegate Naraki, you completed. Delegate Boyce, you have the floor.
Thank you. I just want to offer something up based on what Delegate Naraki said. So we have some of this kind of allowance in Baltimore City, but currently the mechanism works whereas I'm a business, somebody tags my business, and I got to get it fixed up, but I will also get cited by the city for my graffiti, and so I do wonder about using this to uplift the local jurisdictions if they have like a graffiti removal program. So if it's a business per se or a property, could, for instance, it could be that the city maybe removes it and then sends the fee to the business. They would have to be in a contractual agreement that in those cases, and in the cases for this extreme cases where they can get out there quick enough, and other cases where it's just, somebody named Marvin Holmes wants to put Marvin all over the place, right? You can get it off in a reasonable amount of time, but in these cases, it's almost like a contract between the city and or local jurisdiction and the business or or wherever where they can work to like quickly use this. I mean, as far as law enforcement, I'm not sure. I think they fit into this. I'm just not sure they fit in the way that the bill is using them to fit for this. So I'm happy to work with anybody to get this to a place that is I think meets the needs of the sponsor's intent.
Thank you, Delegate Boyce. Any additional discussion on this bill? As I indicated, and as you all can tell by the discussion, there are some concerns about this, and I'd like to have the concerns addressed by additional language, please, ladies and gentlemen. So that's on this particular piece of legislation, HB 699, we're going to hold that. Now, ladies and gentlemen, let's go to HB 486. HB 486 is residential property sales, contract disclosures on Superfund sites. And if you recall the discussion on this one, ladies and gentlemen, this is in reference to sale and purchase of properties. And this legislation was intended, I think, to be specific to residential properties. And this was in terms of purchasing properties in areas of Superfund sites where the contamination levels are pretty high, and a lot of illnesses occur because of the location of the properties within the Superfund sites. And the legislation has been amended. The legislation was asking at the very beginning, and still is, quite frankly, even with the amendments, the legislation was asking, or is asking, that sellers notify the buyers in the contract where that the property is within, as amended, 1 mile of a Superfund site. So what I'd like to do, if you don't mind, ladies and gentlemen, in reference to HB 486, is to go to Ben and have Ben discuss first off the basic language of the bill prior to the amendments, and then go through the amendments, and then we'll discuss additional amendments as well. Ben, you have the floor.
Okay, thank you, Mr. Chair. So yep, I'll pull up the amendments just as a little bit of an overview. The sponsor has some technical amendments or more like minor amendments. The bill is cross-filed with Senate Bill 125, sponsored by Senator Lewis Young. There's no fiscal impact.
Okay.
The testimony was most of the advocate testimony in the bill hearing.
Who else? Oh, I'm sorry.
Most of the advocate testimony was that Maryland Realtors, Maryland Building, and the Maryland State Bar Association's Real Property section were like proposing a buyer notice as opposed to the language that's in the bill. In the Senate, their amendments replace the bill with boilerplate, the buyer notice, for every contract of sale. And I can pull up those amendments and, if that's helpful, Chair Holmes.
Yes, yes. And I pulled up those Senate amendments because I think that what I would like to discuss, ladies and gentlemen, is in reference to the original discussion of the legislation, as I indicated, talks about seller notifying the buyer. And so this is, what was that, Ben? That was the vote.
So, yeah, that was the vote on the amendments, Chair Holmes.
In the Senate?
Yeah, in the Senate.
Okay. All right.
Favorable amendments.
And the and also with the, did you discuss the Senate amendments already, Ben?
I
Okay.
briefly noted that the Senate amendments, they remove the language and just use a buyer notice. I'm trying to pull them up.
Yeah. And while you're doing that, Ben, if I could, after you discuss the Senate amendments, Ben, then I'd like for you to go to the letter from the realtors.
Okay.
Okay, you have the floor, Ben.
Oh, sorry. Oh, yeah. Thank you, Chair. I'm pulling them up right now. So here's the Senate amendments that were adopted. And as you can see, the amendments are the bill in the Senate version. They remove most of the substantive language or all of it, and then the contract, and you can see the buyer notice here. A contract for the sale of real property shall include the following: buyer notice, notice on Superfund hazardous waste sites. A purchaser that receives this notice has the right to rescind the contract within 5 days after the receipt of the notice. And yeah, it gets into that some more with the details of the procedure about how that will work.
While you're on that point, the Senate amendments talk about rescinding the contract in 5 days of receipt of the notice. Is a notice to be provided prior to the contract being signed or after, Ben, on the Senate amendments?
I think this is just the buyer notice. I
Oh,
don't
it's just a
believe
buyer
it's
notice. Okay.
contracting the sale itself.
Okay. All right.
It says honor before entering into a contract of sale may
So it's
not
honorable for.
a purchaser that receives notice required under subsection B on or before entering into a contract of sale may not rescind the contract based on information discovered as a result of the notice. So yeah, I don't think it's the case that, subsequent to the contract of sale or anything like that.
Okay. So this is on or before the contract. Okay. All right. Continue, Ben.
Yeah, I mean, that's pretty much it. It's creating the buyer notice, and yeah.
All right. So what I'd like to do next, Ben, is and I want, ladies and gentlemen, I want you to make sure we understand the distinction between the Senate amendments and the distinction between what the initial bill said. The Senate amendments are talking simply about a notice to the buyer. The initial bill had the seller to notify the buyer, which are two very different things.
Yeah, and if I may, Chair Holmes,
Yes,
the
sir, please.
the House bill, their amendments are on the right-hand side of the screen. And that is, you can see, preserving most of the language that was taken out of the Senate one. They're making changes to the distance that's covered in the notice, 1 mile instead of half a mile based on what's available in the national priorities list. Let's see, they're also they have the addendum that's specifically if the property is located within 1 mile of the specific Superfund site that is being listed. And then at the end there, it says the buyer acknowledges that within 5 days after signing and dating the addendum and on written notice to the seller, the buyer may void the contract of sale and is entitled to the return of any money paid to the seller. I think my understanding is that that's the contract of sale, it then comes before the closing. And that is similar to what, that last part is similar to what is in the Seventh Amendment, but.
Right. All right. And if you could, Ben, pull up the Realtor's letter so that we can get an idea on how the Realtors have looked at the legislation.
Yep. So let's see. Some of the testimony, there's the Maryland Realtors, there was the Building Industry Association, and then the MSBA's Real Property section. Some of this is about the 0.5 miles that you saw in the House bill, but there's also their comment here about in the last few years, most disclosures are generally buyer notices, which is what the Senate version went with. And then I think that's echoed in the Maryland Building Industry Associations. The buyer should be in control of the information presented to them, and the amendment substitutes a buyer notice. And then I think that's similar to the state bar associations.
And those are the two biggest differences between the Senate version and the original House version, is that the documents that we're being shown are suggesting buyer notices as opposed to the seller notice. I saw that Delegate Boyce had her hand up first. I'm sorry, Ben, are you finished?
Yes, I'm done.
Delegate Boyce?
I think Delegate Healy had her hand up first.
I'm
I'll let her
sorry.
go first.
Go ahead, Delegate Boyce.
Go ahead.
No, I said Delegate Healy had her hand up first. I'm letting her go first.
Okay, Delegate Healy.
Okay, thank you very much, Delegate Boyce. My reading of what the Senate language was, really puts the onus on the potential buyer to look it up and go to a government website and try to find it, which, I think that's a heavy burden for somebody who's just looking to buy a property that, that they have, 5 days to do this, and they have to go to some kind of government website, try to figure out how to find something on a government website. I mean, it's one thing to get a notice that says this is definitely known that it's within a mile. I kind of like that it's more clear in the House version than the Senate version. I'm just not sure how that is a reasonable thing to ask somebody who's trying to, negotiate through the stack of things that you signed before going to closing.
I appreciate Delegate Healy, and that's exactly why I wanted to show you the two different versions so that we as the subcommittee could understand the argument that's taking place. Delegate Healy, thank you. Delegate Boyce?
Mr. Chair, all due respect, and please put me in my place if I'm incorrect. We usually don't allow sponsors in the subcommittee, but I think we have the sponsor here. And I don't know if that was so that you can call on the sponsor or so that the sponsor can observe.
Typically, as you indicated, we don't have discussions with the sponsors. I would particularly like to stick with our.
I'm just double checking that is the rule. Thank you.
Yes, indeed. I don't mind that the sponsor is observing. That's fine. Thank you very much. Delegate Lehman?
Yeah, thank you, Mr. Chair. I concur with Delegate Healy. I'm very concerned about, putting the burden on the buyer to go on this sort of, what could be a very challenging process to the federal government lists these sites and determines the national priorities list. It's never easy to find federal information. I spent years trying to track down the repository for the various Superfund sites at the Beltsville Agricultural Research Center. which is in my district, and it was nearly impossible. I do not think this is fair to buyers. I think shifting the burden this way is inappropriate. I appreciate seeing this to, be aware of what happened in the Senate, but that's what conference committees are for. And, I much prefer the way Delegate Fair and the co-sponsors, the Delegate Fair, obviously taking lead on this, and others put this bill forward, where the onus is on the seller. I would hope we would stick with that language. I do have a question though about the radius. Could you clarify? Can Ben or someone clarify? Did that change, or is that proposing to be changed? That 1 mile, properties within 1 mile of the Superfund site, or is that remaining the same?
It has changed. The legislation, the bill originally came in as a half a mile. It is now 1 mile. And
Okay.
that the sponsor put that in as 1 mile to adhere to the realtor's request, one of the realtor's requests. So
Okay.
that was a sponsor amendment to change it to.
Okay. Yeah. Thanks for the clarification. That's all for me. Thank you.
Sure. And ladies and gentlemen, the reason why I wanted to give you the Senate amendments is because as chair of the subcommittee, I want to make sure we have all of the information at our disposal for us to make decisions. Delegate Lehman, have you terminated your discussion at this point? Delegate Baker, you're up.
Thank you, Mr. Chair. Back to this 1 mile radius. You just made the comment that the realtors asked for that.
Yes, sir, that is correct.
And then you also had said that they had another concern.
The other concern on the realtor letter was that typically these types of disclosures are buyer notices and not seller notices. And that buyer notice that is indicated on that letter would be consistent with the Senate amendments. Ben, could you expand upon that?
That's my understanding as well, Chair Holmes. I believe there may be an advocate or two on that same position with Maryland Realtors, but they have in their testimony, they have half a mile, adjust how that might be problematic. And then, but they also say propose the buyer notice.
Delegate Lehman, you still have your hand up. There's another question.
Yeah, just if I could get clarification that this bill, I thought it had pretty broad agreement. Now that might have been changing the half mile to a mile. I don't know when that came in, but I thought this was a consensus bill, or that was my understanding. Am I wrong about that?
Well, the 1 mile was in the testimony by the letter from the builders. And that was the 1 mile was then revised by the sponsor of the bill.
Okay, so that would be considered a friendly amendment. Is that accurate to characterize it that way? And that what it took to get I think you keep saying the builders. Do you mean the realtors?
I'm sorry, I meant the realtors. I'm sorry. Yes, sir.
Yeah,
Yes,
that's what that took to get them on board. I don't think we should mess with it in that case, but that's my view.
okay, thank you. Delegate Baker, you have another question?
Yes, Mr. Chair. So back to the realtors. So what is their position on this bill as it's been amended? So are they 100% in support of the bill currently?
That I can't address at this particular point. I don't know if they're 100% on board. I do see a realtor on here now. Let me go to
that would be important to me.
Delegate Naraki.
Oh, thank you, sir. Thank you, Mr. Chair. Mr. Chair, I'm just curious, and maybe this gets to Delegate Lehman's point, but I was just kind of poking around while we were on here trying to find this this dashboard, this tool that's on the website. It is very difficult to navigate. I don't know if I don't know how to solve that, but I'm just concerned that we're putting that onus on some folks that it can be very hard to find that tool. I would hate to see someone kind of get caught up in a legal situation with a tool that's not easy to locate on the website.
Okay. Delegate Lamy, you have your hand up still?
No, sir, I'm sorry, Mr. Chair. I just keep forgetting to put it down. I'll do that now.
All right, Delegate Baker, you still have a question?
Yes, I thought we were waiting on a realtor to give us some comments. You said there was,
Well, you know, I'm trying desperately not to turn this into
I understand.
um,
No, I understand. Okay, so then my other question would be the builders, have they proposed any amendments, or are they in support of the bill currently?
that I do not know. And if it's the pleasure of the subcommittee, I'd like to get something out of here. And I don't want to turn
I'd
this
like to
into-
move the amendments, Mr. Chair.
And I'll second that.
Great. We have a motion and a second on the sponsors amendment. And that's what you were referring to, I assume, Delegate Boyce.
That is true. Yeah, yes, Mr. Chair.
All right, thank you very much. We have a motion and a second on the sponsors amendments. Any discussion on the sponsors amendments, ladies and gentlemen? Okay. I'm gonna, on this particular one, I want to make sure everyone has their voice. Yeah. So now, all in favor of the sponsors amendment signify by saying aye.
Aye.
Any opposition to the sponsors amendments? Hearing none, we are now on the bill as amended. Do I hear a motion?
I'll move favorable on the bill as amended.
Second.
And we have a motion and a second on the bill as amended. Any discussion on the bill as amended? All in favor of this is HB 486 as amended, signify by saying aye.
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 Any opposition to HB 46 as amended? Does anyone need to take the rule on this? Fantastic. HB 486 will receive a favorable report from the Housing and Real Property Subcommittee. Ladies and gentlemen, we will now go to HB 285. HB 285, ladies and gentlemen, is, if I can go to my notebook here, HB 285 is a bill related to task force on property appraisal and evaluation equity. And outside of the sponsor of this bill, it is a pretty good bill. It's pretty simple, like I said, without respect to the sponsor. What this bill does is just two things, ladies and gentlemen. It changes the language in reference to the Supreme Court of Maryland because as of a recent year or so, the Maryland Court of Appeals is now the Supreme Court of Maryland. So the bill does in fact address the new change in the name of the Supreme Court of Maryland. In addition, what the bill does in the last page of the bill, page 3, is it moves the reporting date from June 30th of 2024 to December 31st, 2024. And ladies and gentlemen, the reason why that date was moved out was because I don't want to throw anyone under the bus, but admittedly, there was a lot of new legislation coming in with the new administration, and they kind of missed the deadline. So I'm just allowing them to get additional time frame to meet the deadline of the final report. Ben, you want to expand upon those things, please?
Yeah, thank you, Mr. Chair. The sponsor's favorable. The cross file is SB 518 by Senator Alonzo Washington. There's no fiscal impact. The testimony is all favorable. So, and yeah.
And the department is in favor of this as well. And I would like to have a motion on this bill, if you don't mind, ladies and gentlemen.
I'd like to move the amendments, Mr. Chair.
Second,
It's actually, there are no amendments. This is a straight bill. Correct.
Sorry, then I'll move the bill.
and
Thank
I'll
you.
second that.
And, all right then. And all in any discussion on HB 285? Seeing none, all in favor of HB 285 signify by saying aye.
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 Any opposition on 285? Does anyone need to take the rule on this? Seeing none, HB 285 will receive a favorable report from the subcommittee. We'll now move to HB 926. And HB 926, ladies and gentlemen, is, as I scroll through my notebook to find it, HB 926 is Maryland Building Performance Standards, local request for guidance of religious consideration. And as we heard in the testimony on this bill, it appears as if the bill sponsor and the supporting members of the sponsors of staff were looking for guidance on this particular piece of legislation, guidance only. And Bill, if you could expand, Ben, if you could expand upon that, I appreciate it.
Okay, thank you, Mr. Chair. Yep, so just as an overview, this was presented by Delegate Griffith yesterday. There is sponsors favorable, the cross-file, the Senate Bill 1033 by Senator Carter. There's no fiscal impact. The Maryland Department of Labor and the Office of Attorney General can handle the bill requirements with existing budgeted resources. The testimony that was given was all favorable. And then as background, as you may remember, the bill originated with the issue where a local synagogue had a new structure built. This required occupancy sensors under state law and the Conservation Code. It created a problem with the religious group's observation of the Sabbath because the lights were being automatically activated. And this was a violation of their right to express their faith. The bill requires the Department of Labor, on request by a local jurisdiction and in consultation with the Office of Attorney General, to provide guidance for implementation and enforcement of the building performance standards as they relate to religious observation. So there's federal funding for implementation of energy codes, and it has stipulations that prevents the state from amending the code. But the goal, and as the sponsor presented yesterday, was that they have a letter from the AG that this will help bridge the gap of allowing exceptions without risking the federal funding that's provided for these energy codes. And then the sponsor also added that the MDL has no issue with the bill.
Thank you, Ben. And there are no amendments to this bill. Is that correct?
That's correct.
Right. Thank you very much. Delegate Naraki, you have the floor.
Oh, thank you, Mr. Chair. Where are we with, this is more a broad question dealing with this bill. Where are we with BEPS in general? Didn't it get held up in ALR, or am I thinking that wrong there? Ben,
Bill? Are you talking about the bill itself?
BEPS,
What is that?
building energy performance standards. Sorry, should have been more clear, Delegate.
Thank you.
I'm not aware. Ben, can you expand upon Delegate Naraki's question? I'm not even sure what the question is relevant to on.
I believe those standards are what has necessitated the need for these sensors. So I just kind of broadly wanted to know where those standards are to just to kind of frame the context of where we are with all of this, Mr. Chair. I'm sorry, I should have phrased that question better. I apologize.
Yeah,
it's late.
I got it. now I understand, Delegate Naraki. I think part of the issue in addressing your question is why the legislation is the language in the legislation is geared towards seeking guidance. That's what I think. Ben, can you expand upon that?
Yeah, thank you, Mr. Chair. So if you are looking at the bill, that's where it says shall provide guidance for the implementation and enforcement of the standards in relation to any religious observance, practice, or belief. And then standards in this part of the code means the Maryland Building Performance Standards. I'm not sure. I think for what it's worth, this was an issue that the sponsor was bringing with advocates who were, their testimony was that they were being hindered by this. So, yeah, I'm not sure about the exact status of Maryland building performance standards, or if there's a nuanced distinction between that and building energy performance standards.
But I think
I believe the energy standards or the building energy performance standards are what's necessitating this. I believe I could be wrong about that, Ben.
Yeah, and to piggyback on your question there, Delegate Naraki, I think that's exactly why they're seeking administration, Attorney General's guidance as well as some others to figure out what it is they need to do with it.
Okay.
Delegate Boyce, you have the floor.
Thank you. And I was going to just say that I don't believe that BEPS will have anything to do. So in other words, I don't think, as I understand it, this is a request to not help meet those standards. It's just saying the standards are causing them to have an issue with Sabbath observance, true Sabbath observance. So for instance, I don't think, for instance, and I guess this is where the guidance is going to help, that they clearly have automatic lights. Like they're not going to revert back to having lights, but they have to physically turn on and off, if I'm correct. But that is how I understand this.
And I'm in agreement with you as well, Delegate Boyce, which is why the entire bill is a request for assistance. There are no amendments on this bill. Is there someone that wants to make a motion in reference to HB 926?
Move the bill, Mr. Chair.
Second.
Second, and there's a second. Any discussion on HB 926? All in favor of HB 926 indicate by saying aye.
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 Any opposition on HB 926? Seeing none, the HB 926 will receive a favorable report from the the Housing and Real Property Subcommittee. What I'd like to do now, ladies and gentlemen, is go to HB 853. HB 853, ladies and gentlemen, is a bill discussing residential leases, late payment penalties, and calculation. Now, this bill is brought by the good delegate within our committee here, and although it has definite sponsor problems, the bill is pretty simple in its context, and what the bill does is it clarifies that late payments should be made on unpaid rent and not just rent. It's pretty simple in terms of its discussion. And Ben, if you could expand upon the bill in its entirety, which is one word, if you could, Ben, expand upon the bill.
Okay, I'll try, Chair Holmes. So the sponsor is favorable. There's no cross-file, there's no fiscal impact. All testimony is favorable. Specifically testimony from CASA, the Office of Attorney General's Consumer Protection Division, the MMHA, RMI, Public Justice Center. You mentioned this a little bit. the bill seeks to add clarification regarding exactly what is owed by tenants. So the bill prohibits a landlord from charging a penalty for the late payment of rent that exceeds 5% of the amount of unpaid rent due for the rental period for which the payment was delinquent. The Office of Attorney General's Consumer Protection Division notes that the bill clearly identifies that the maximum penalty a landlord can charge a tenant for unpaid rental amounts is 5% of the amount unpaid instead of 5% of the full monthly rental amount.
And there are no amendments to this bill. Is that correct, Ben?
That's correct. And I believe, yeah, the sponsor had their hand up, but I'm not
Right.
sure.
And no one is opposition to the bill, even though it has a sponsor problem. Is that correct, Ben?
There's that testimony in the floor system that says unfavorable, but there's no testimony submitted. And then there was another info, but there's no testimony submitted. Yeah.
I understand. Delegate Allen, you had your hand up first. Is there something you want to add to this discussion, Delegate Allen?
No, Ben pretty much said it all, sir. First of all, I want to test. Can you guys hear me now?
Delegate Lehman?
I was just going to joke and say, just because he can't speak for himself today, you shouldn't be picking on him, Mr. Chairman. That's not fair.
Delegate Noraki, you have your hand up.
Thank you, sir. I appreciate it, Mr. Chair. Just hypothetically, could since the sponsor's here, or maybe you, Mr. Chair, could we just walk through it real quick, just so I understand the mechanics of how it works exactly, the 5%, just real quick. I'm not opposed. I just wanted to wrap my brain around it. That's all.
That is not a problem. The 5% is existing law in existing language. And what the existing language and existing law says is that a 5% can be attached onto rent that is due. And what the bill does, the bill simply adds one word. The bill simply adds unpaid. So instead of being ambiguous and then paying 5% of rent, the bill says 5% of unpaid rent.
Gotcha.
Yeah. Ben, can you expand upon that, please?
Yeah, and I think for what it's worth, the Office of Attorney General's testimony does a good job of addressing this too. But yeah, the issue is about what type of rent is being considered to be due.
Right.
So based on that, it's the goal of the bill is the landlord can charge a tenant for unpaid rental amounts that are 5% of the amount unpaid instead of 5% of the full monthly rental amount.
Right. And the bill is just trying to make a distinguishment between the rent and the unpaid rent, which I think is a very good scenario. I know that I, as chair of the subcommittee, had this listed as discussion only. However, I think that if there's someone who wants to move the bill, we could probably get this done pretty simply.
I'd like to move the bill, Mr. Chair.
I do appreciate that. Is there a second?
Second.
Fantastic. We have a motion and a second on HB 583. Is there any discussion on HB 583? Hearing none, all in favor of HB 583 indicate by saying aye.
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 In his opposition to HB 583, Delegate Allen, how do you wish to vote?
Aye.
HB 583 will receive a favorable report from the Housing and Real Property.
Is it too late to revoke my vote? I don't know anymore.
Card laid is a card played.
Roll call, Mr. Chair.
Thank you, ladies and gentlemen. Now I would like to go to the final bill of our evening. And this is the bill is HB 477. And ladies and gentlemen, this bill I would like to have a full-throated discussion on. I do not want to have, I will not be entertaining motions on this bill this evening. We will be entertaining motions on this bill, and we'll be entertaining amendments if necessary on this bill next week. The bill is HB 477. And HB 477 is a bill that is entitled Residential Leases and Holdover Tenancy Just Cause Termination Provisions. HB 477, ladies and gentlemen, is a bill that has been before us several times before. And what the bill does in a nutshell, ladies and gentlemen, is that it provides local jurisdictions the opportunity to look at how holdover tenancy is addressed. And holdover tenancy is also identified in the bill as well. And the bill outlines specific criteria that local jurisdictions can put together for their own, each jurisdiction, in terms of how they will handle how they will handle holdover tenancy in their jurisdictions. And as indicated at the top, ladies and gentlemen, we will not be entertaining any motions on this bill, and I want to have a real great discussion on it so that we can take a look at it next week. Ben, if you could expand upon HB 487, I would appreciate it.
Yeah, thank you, Chair Holmes, and I'll do this as quick as I can, and hopefully we can just hit the main points, and then we can go from there. The cross file is Senate Bill 644, Senators Muse, Carter, and Sidnor. The fiscal impact, the fiscal note says that general fund expenditures for the AG's office may increase depending on the extent that local jurisdictions enact local laws or ordinances authorized by the bill. The bill, I think you went over well what it does. The testimony, there was a lot of favorable testimony, including the Office of Attorney General's Consumer Protection Division, NACO, DHCD, Disability Rights, Public Justice Center, many counties as well. The Legislative Black Caucus was favorable. A lot of this testimony, including the sponsor's testimony, noted that at least 5 states, the District of Columbia and 16 localities have adopted just cause eviction laws. There was also unfavorable testimony. The Maryland Judicial Conference said that the bill could cause the landlord-tenant law to apply differently in one jurisdiction out of 24, resulting in inequitable application of the law across the state. AOBA was arguing that this makes it more difficult to remove nuisance tenants, that the housing provider cannot document and prove the offending behavior, the tenant will never be removed. There was testimony that housing providers have a built-in financial disincentive to pursuing evictions. Turning over units has a significant cost. It was also added that about 1% of tenants are the subject of repeated neighbor complaints due to their conduct. However, the vast majority are not. Maryland Realtors said that the tenant commits a breach that is not substantial. The tenant could repeatedly make small breaches of the lease, which we'll see if we take a closer look at the bill. So yeah, we can go through the bill, Chair Holmes, however you want to do it.
Thank you, Ben. What I'd like to do for additional discussion, ladies and gentlemen, is for Ben to go through the 6 points in the bill that requires just cause, which identifies just cause for tenant holding over. And these 6 points are the perimeters that the bill is asking for the local jurisdictions to include in their enabling legislation for a just cause of tenant holding over. Ben, if you could go through these, so for additional discussion, I'd appreciate it.
Thank you, Chair Holmes. So, yep, this is just cause that's proposed by the bill. So they have various items. Substantial breach of the lease is in point 1 here. So if there's person is substantially breaching the lease and they fail to comply within a reasonable period, that would constitute just cause. There's disorderly conduct in point 2, failing to cease that. Point 3 is illegal activity on the premises. Point 4 is impeding access when the purpose of making repairs or improvements, inspecting the lease premises, or what's otherwise authorized under the lease or applicable law. Point 5 is use by the landlord or the landlord's spouse, and so they want to recover possession for themselves or their family. The permanent removal is item 6 there. And so one thing to note is that it's up to the county. The county provisions can be one of these. This is guidance, and that's more clear in subsection C here. The county may enact by local law or ordinance provisions that prohibit a landlord from failing to renew a lease during the lease period, or when the tenant stays over on the lease, the holdover tenancy, without just cause.
Okay. Now, if you could do me an additional favor here, Ben, go to page 4 and then go through paragraph D, which talks about what the local jurisdiction shall do in their ordinance.
Yep. So D provides a lot of the procedure that is required for the just cause enabling legislation that this bill has. So there's in D1, the landlord has to provide written notice to the tenant stating their just cause basis. In B, it has to be a statement of the just cause. D3 is specific facts demonstrating the just cause. And this all, the reason that like counties can't go ahead and do this on their own already is based on case law where, the Baltimore City had passed a law that would have restricted landlord lease non-renewal as a way to evict a tenant. But there's the existing 8402, which is for terminating tenancies in the code right now. So the Supreme Court of Maryland held at that time that the city could not do that because it would conflict with this law. So that's why kind of some background too on the bill.
And I'd like to make sure that we all understand what provisions of the law this is applicable to. This is only in reference to a tenant holding over. And a tenant holding over is if a tenant just does not leave once the lease has expired. Well, that's not quite true either. If there's if for example, there is a 1-year lease and no action is taken by the landlord to ask the tenant to leave, then the 1-year lease at the anniversary date automatically turns into a month-to-month lease. And in a month-to-month lease, it just continues on in perpetuity until some action is taken. And this particular legislation, just cause, is only relevant to that particular case, a tenant holding over. If you could expand upon that, Ben, I certainly would appreciate it.
Okay, Chair Holmes. Yeah, you got it. The C1 there, it's it's for the tenant who's holding over, or for during the lease period. So the just cause has to be provided for failing to renew a lease during the current tenancy, during the lease period, or the holdover tenancy, which is what happens like after a lease that's in writing or a formal lease expires. That is kind of addressed in 8402 about how the tenancy becomes, in D here, when a landlord consents to a holdover tenant remaining on the premises, the tenant becomes a week-to-week tenant. If they were a week-to-week tenant before the tenant began holding over, or a periodic month-to-month tenant, which is usually the case with most of your standard yearly leases.
Correct. And we had, I'm sure, ladies and gentlemen, you all remember the testimony on this. It was quite lengthy, and both on both sides, favorable and unfavorable, as well as favorable with amendments. So at this point, what I'd like to do, ladies and gentlemen, is to open up the floor for us to have discussions. And as I indicated at the top, I would like to have full-throated discussions on this piece of legislation. And I'm also inviting everyone here within the subcommittee to send us your amendments to this bill as you think it should be adjusted. I'm going to start with Delegate Lehman.
Thank you, Mr. Chair, and thanks for the review, Ben, and the opportunity for discussion. So quickly, I wanted to ask about numbers 5 and 6. I'm pretty sure that those are already legitimate reasons for not renewing a lease, right? If you want to make the unit available for a family member, I think is number 5. And then number 6 is if a landlord is planning to take a unit completely off the rental market. Is that accurate, Ben? That those, I believe that's already in law. Those are legitimate reasons to not renew a lease. So if that's the case, there's only 4 conditions that, I mean, I know that 6 have to be listed, want to be covered, we want to cover those, but I think those 2 are already legitimate reasons for non-renewal.
Yeah.
Yep. Thank you, Mr. Chair. And I can go back to sharing my screen share if you think it's helpful for looking at it, but it's up to you.
Yeah. So yes, do the screen share, Ben, and then once you screen share, go to 5 and 6. Delegate Lehman is suggesting that numbers 5 and 6 are current law. So if you could discuss that, Ben, I'd appreciate it.
Yeah, my understanding, and I could be wrong, but I think kind of the basis is that right now, the landlord at the end of the lease doesn't have a requirement to renew. So they can have any cause or no any cause for failing to renew a lease. I'm not sure if it's about if the concern is about leases that are currently signed, if the landlord has like that type of reason, but yeah.
And if I could expand upon that, Delegate Lehman, the reason why we have the just cause in front of us based upon the sponsor's suggestion is that right now, when a tenant's lease is expired, no reason is necessary to be given to them. And I'm not aware of, in direct answer to your question, I'm not aware of 5 or 6 being a requirement in current law.
I don't think it's a requirement per se, but I think it's a valid reason for non-renewal. That's my understanding. If say this person has been a model tenant, then and there's no reason otherwise, and I know there's not a law right now, and that's what just cause is about, is an attempt to protect tenants for not having a lease renewed for no apparent, no good, no documented reason. But I just was under the impression that was already, that was a valid reason if that is given, that's not something you could challenge in court, in other words.
Yeah, you're correct. The valid reason is the valid reason is what 5 and 6 is trying to put together for just cause. Yes, that is correct. They're saying you have to do.
Okay. Well, I think it's getting late and I don't think I'm communicating well, but the other point I wanted to make, or question is that to reiterate that this is enabling legislation and that this, is it accurate to say then as enabling legislation that we're kind of setting the floor and local governments, in this case, counties, I don't think municipalities can enact just cause. I don't think. So counties, at a minimum, if they're going to adopt enabling legislation, would adopt these state standards, but could have higher standards. Is that accurate?
Yeah, I think that is. Well, let me see. First off, you're correct in that it's for counties only and not municipalities. Yes.
Right.
Could they have higher standards? Ben, this is just cause may include, so if a county enacts this just cause, could they have more stringent requirements, Ben?
Yeah, it's up to the counties what they want to do with their just cause. But the just cause, so I think in the 1 through 6 here are examples of what just cause could include. But it would be a county may enact by local law provisions that prohibit a landlord from failing to renew a lease. So it's really up to the county about the type of means grounds established by local law or ordinance that justify the non-renewal of a lease. So it's very broad. It could be less than these 6, I suppose. You could just do one of them, but yeah, it's up to
correct.
the counties.
And that's my understanding as well. It could be less than the 6 as well. So you are correct in my understanding of it as well.
Thank you. That's it. Thank you.
Delegate Naraki?
Okay.
Thank you, Mr. Chair. Sorry, I couldn't find my button that was hidden. So Delegate Lehman, actually, I had another question, but she just made me think of one that I wanted to ask as well.
Just open discussion.
Yes, thank you, sir. So if since this is enabling legislation, and I think this gets to part of this concern that you sorry, I can't speak late night, the judicial branch has here. I'm concerned about creating potentially 24 different, essentially marketplaces here with this, because obviously each county could create their own version of what this looks like since this is enabling. How do we address that here? Because I think I think other states, and I could be wrong, have done this sort of in a statewide way and not created potentially all these different county by county models.
And you are correct, Nat, and you reading the opposition states exactly that. And to answer your question, what could in fact take place is that there would be legislation to create this just cause statewide, which would in fact then make all 24 jurisdictions have the same requirements.
Okay, so it would just be kind of just not making it enabling, but just a statewide bill. Okay, that answers that part of my question there. My next question, Mr. Chair, is I'm concerned about what may be a substantial breach. So we've had some discussion inside of our committee this year with respect to smoking inside of buildings, right? I mean, we've had the candy industry, as our chair has talked about there. So my question is, if someone is a smoker, and I'm just kind of throwing out a hypothetical here for us to think this through. If they are a smoker, and they get complaints from neighbors around, particularly neighbors around that might have asthma, and we go to court, I don't believe that is a substantial breach of the lease, but the landlord in this case may lose other tenants because those folks can't live around someone that is a smoker because their asthma or whatever other conditions that they may have. So how do we address a situation like that?
I think it would be incumbent upon us to make some revisions to some of those languages, because if you look at paragraph 1 here, you're exactly correct. It says substantial breach of lease causing substantial damage, and then at the bottom of that page 1, within a reasonable period of time. And down in paragraph 2, it says a reasonable period established under local law. And then in paragraph number 4, it says a tenant without reasonable cause. And then in paragraph number 6, I'm sorry, that's all it says there. But there are several instances here where the language in the bill uses those terms, reasonable and substantial. And if it is the will of the subcommittee to revise that language to be more focused, then that's what we would have to be doing.
Okay, and that makes sense, Mr. Chair. I mean, and my concern with that, kind of taking that further out, is in a scenario like that, or any of these scenarios, frankly, you are potentially pitting neighbor against neighbor. And I'm I'm a little uncomfortable with that. I mean, the only way to prove some of these things in court would likely be a testimony from one neighbor against another neighbor. You know, whether it's the smoking issue or whether it's maybe a noise complaint or whatever the case might be. And I'm not so sure that that necessarily creates neighborly community. So I'll describe it that way.
And some of the discussion was, as I recall it, if, for example, the landlord has a property manager in control of their building and or their building, I'll use that example, then the property manager should have documentation in terms of the disturbances, and that documentation could be used or perhaps could be used in a court of law to substantiate their case of tenant, violating breach of lease. So that was one of the arguments that I recall hearing from the testimony. But you are correct. There could be some cases where there may be some discussion requiring tenant versus tenant.
Mr. Chair, would the property manager have standing there? I mean, I would think that the tenant would actually have to testify because they're the one that has the actual knowledge in this case. I hear what you're saying, Mr. Chair. I'm just talking this out with you here.
Oh yeah, and that's talking it out is exactly what it is that I intended to do. I was just trying to say that perhaps if a particular tenant said that the next door neighbor was having a substantial breach of the lease, then if the property manager had documentation of such, then perhaps it may not necessarily have to be tenant versus tenant. But I'm not saying that that's true. It's just additional discussion for us to weed through here. You know what I mean?
Yes.
And I do appreciate the discussion. I'm going to go to Delegate Boyce next, and then to Delegate Healy.
Thank you, Mr. Chair. And thank you for having this good dialogue. And I want to thank Delegate Naraki for bringing up something. And so one of the things is that, a couple of places across the country has this. And I know, and I'm looking at all the notes that I typed in my floor system when this hearing was happening, but they were saying how, different cities, places across the country have this, and there's been no quote unquote, no issues. But it is true that New York court struck down good cause eviction because it exceeds the city's authority. And two, I think it was Delegate Naraki's point is that then this would, as a piece of legislation, giving local authority creates those multiple different systems and laws throughout the state. And then I think essentially, as I would read it, would get struck down versus if we did state law, not necessarily enabling it, this would have to be state law for the state on just cause or good cause eviction, however folks want to call it. And I wanted to bring up that point. I think, and to that other point, that the bill brings up a lack of certainty about when one can pursue actions and when one can't. Like what's the balance. And as I see this with tenant holding over, for me, one or two things has to happen. The landlord needs to issue a lease, or at this point decide that they're going to pursue eviction and therefore say, it's month to month, the lease is up, and then start those proceedings for the individuals to move out. And so, and I know from the advocate's point of view is that a lot of this really gets, once the bill or the concept, it tries to get at one, retaliatory evictions, and two, trying to get more data kind of on evictions or why people are let go at the end of a lease or not. And so I get all that, but I think in general, trying to strike a good balance between protecting tenants and landlord rights feels like, how does this bill kind of solve that without, again, unnecessarily, quote unquote, evicting or pushing out individuals for whatever reasons I think most people think it happens or why it happens.
Yeah, that is, in my opinion, in reading the legislation and listening to the testimony, that does appear to be the primary reason for the uh, just cause in this case, or good cause in other jurisdictions calling it. It basically means the same thing, that there should be, the intent, as I read it, is that there should be some reason for the landlord not to continue to allow the tenant to stay in the unit or the house. Delegate Healy.
Oh, thank you, Mr. Chair. I have a couple questions. And one is this whole idea of a substantial breach of the lease. I mean, what that means, if it whatever rises to the level of being substantial, that kind of, it seems to me, negates the whole point of having a lease that says there's a lot of things you can't do. You can't, hang a picture on the wall, or you can't have a pet, or you can't smoke, or you can't paint it a certain color. All those things that they're maybe minor, but they're all in there in detail, and you agree to them, and you sign a lease, and you say that while I'm living here, I'm not going to do those things because I'm renting and I'm not the owner of this property. So, I mean, there's a whole range of stuff, right? There may be things that are more substantial than others in somebody's opinion, but painting the walls black, and then as long as you can paint them white again before you leave, maybe it's not a problem. But there's a lot of questions that I have about that aspect. I'm not an attorney, and I don't know how important it is that you do this, because I know that they're like these standard leases, and they're all generally written to the benefit of the landlord, because they're the ones who are writing the lease, and the tenant either agrees or goes somewhere else. So it's not an even contract, it's not between two equal partners.
Right. And that's something that I brought up earlier, in that in in multiple cases on this particular page, you'll see the word substantial or reasonable being used throughout this. And what I suggested earlier is that perhaps the subcommittee may want to tighten up that language to redefine it so that it may not be so vague. Which is one of the reasons why I wanted to have this discussion. Delegate Healy.
And the other, I just have one other piece, which is I listened to what Delegate Boyce said. I was thinking perhaps this situation with the tenants holding over, if we don't do this carefully, could have unintended consequences of having everybody have to leave after only 1 year, or renegotiate a lease, or and not have it automatically go to month, that you could, which is beneficial sometimes for one or the other. They can just leave whenever they want. They're not obligated to pay rent for a whole year. So I think we need to maybe think about some of the back and forth on what really is the intention here.
Right.
Okay.
And I agree with you, Delegate Healy, which is why I indicated I want to have a full-throated discussion. Typically, a tenant holding over in those terms is the holdover portion is defined as when the lease agreement is over. In a year-long lease, obviously that would be the 12-month time frame, and then after that, it goes to a month-to-month automatically, and then that is, where the legislation that we have in front of us, if the landlord is asking that the tenant leave, they have to give good cause or just cause in terms of why the landlord wants them out. But you're right, and in terms of unintended consequences, Delegate Healy, which is exactly why I want to have this discussion. And as I indicated 3 times already, I would like to see some amendments coming from the subcommittee members to address some of these discussions we're having. Delegate Naraki, you have the floor.
Thank you, Mr. Chair. And I appreciate Delegate Healy and Delegate Boyce's conversation here. To Delegate Healy's point, one of the unintended consequences that I'm concerned about is that we see a substantial increase in litigation here in the courts to determine what is just cause and all those sorts of things. And I'm concerned about if there's a lot of litigation, that ultimately those costs are going to be passed along to either the current tenant or future tenants, because someone's got to pay for all that all those court fees potentially that are going to be, all those lawyer fees is what I should describe it as. So I'm very concerned about that here. But I've been really digging into this, and one of the things that I've been really trying to find, and I don't know if Ben or anyone has an answer to this, but are there any other types of contracts in Maryland that can be extended by one party without the other party's consent? I can't find any other example anywhere in Maryland law, but maybe there is. So I'm very concerned about kind of setting precedents there like that, where we create contracts where one party can extend it without the other party consenting to that.
Well, this is what I'm going to do, Delegate Naraki, in terms of that. We have a substantial number of persons listening on this discussion. And so I'm asking that anyone and everyone that's on this discussion address Delegate Naraki's question and send the answers to us so that we can get some definitive answers on that in terms of other contracts that can be extended like this on a one-sided basis, I guess. So I'm asking everyone on this call who wishes to address Delegate Naraki's question and send it to us, please. Good question, Delegate Naraki. Delegate Baker, you have the floor.
Thank you, Mr. Chair. I guess for me, I'm just sitting here and listening to everybody, rereading some of the information in the bill, and I'm really having a difficult time. I'm a landlord. I'm nice enough to rent my property out for 12 months, and the tenant and myself agree to this lease. So at the end of, and you want me to send a letter out, I think 60 days, 90 days before the end of the lease to state that I don't intend to renew the lease. That's the agreement that we've already entered into. And in that letter, it could simply say, I would love to renew the lease with you. Or my letter should say, I do not intend to renew the lease. I don't understand why I have to give a reason, because in the agreement, we've already agreed to 12 months. They know that, I know that. This is the difficulty I'm having with it. And then you're saying it's enabling legislation. Well, I can tell you, if I'm a county elected official, I'm not touching it. But that would be my position. I would let the agreement that was entered into, that's between the tenant and the owner of the property, who has all of the financial responsibility, really. And that's kind of where I'm at on this. I really have difficulty buying into this.
And Delegate Baker, that's exactly why I wanted to have this discussion. The type of discussion that you're having right now is the way some feel as well. But the other side of that coin is that some landlords may be using the end of the lease as an opportunity to get the tenant out, to increase the rent, or get the tenant out because of some retaliatory action. And that's why I wanted to have this discussion, so we could kind of filter some of these things out. And like I want us to figure out what language we want to put into this bill. And we can't figure out what language we want to put into this bill until we have this type of discussion. And so, Delegate Baker, if you've got something that you want to put into this, by all means, please, and I'm inviting everyone, write it up so that we can have this discussion again next week and get this bill tied up into, get this bill, finalized, if you know what I mean. That's what I'm really trying to do, is for us to have a healthy, full throated discussion so we can figure out what it is we want to do with this legislation. Delegate Baker, you got additional comments?
No, no, I'll put my hand down, but again, I just can't understand why if I enter into one of your properties, if you and I enter into an agreement and you give me a 12-month lease, 90 days out before the end of the lease terminates, you send me a letter stating that you don't care to renew the lease. That's what we already agreed to.
Right.
I don't know why we're trying to force people to have to agree to something that they didn't already agree to.
Right.
I think
I think that if we could have someone to address Delegate Naraki's other question, is this relevant to any other types of contract that might help us out as well? I'm going to go to, if you don't mind, Delegate Baker, I'm going to go to Delegate Allen next.
Thank you, Mr. Chair. Can everybody still hear me?
Yes, we can. Congratulations on getting your audio fixed.
Oh, I didn't get it fixed. I just had to dial in on my phone. But, you know, whatever. Going back to, I know we had talked before about, you know, the just cause, the list that's in the bill, of what just cause may include. And I think someone had mentioned too that, you know, we're kind of setting the floor here. Would it be helpful in that regard if we, you know, and we might have other things we want to add to that list. But if we're interested in setting the floor, should we change the may to a must and say at a minimum, you know, counties just cause, you know, reasons must include at least these, you know, these items?
I think we can. And also, as I look through the bill, yeah, I think that what you're suggesting, Delegate Allen, is a great idea. And on the last page of the bill, it talks about some of the things that the local ordinance shall require. I think it's D, and maybe in conjunction with those 6 items that you're speaking of, Delegate Allen, perhaps paragraph D, starting with line 9, could be beefed up to address that issue as well.
Yeah, I mean, I don't, you know, thank you, Mr. Chair. I know no, you know, I said this in the hearing as well. I know no list will ever be exhaustive. But again, if we're interested in, you know, enabling legislation that's going to be setting the floor for this, that might be the approach to help make, you know, and again, I know we have other disagreements about this too, but I think this might make a lot of people feel more comfortable at least.
Sure. But like I said, I'm saying it ad nauseum here. Please send us something so we can address your issue. Delegate Boyce is next.
Thank you, Mr. Chair. And to Delegate Allen's point about setting the floor, and I think it was per Delegate Lehman, I think I still worry about that, because if this is statewide, everyone would have to be on the same playing field, because it cuts out the quote unquote rent court argument that somehow folks have to play different rules and different rulings in different courts if a judge has to go to one place or the other. And so I don't know how much setting the quote unquote floor then aids potentially to still, because we're saying we're setting the floor, which means that per your jurisdiction, you could set your own ceiling, which is fine, I guess. But then does it get back to the point I think some of us been making, I know Rocky made it and I made it as well, is that you have different quote unquote just cause laws per jurisdiction. And so I think there's I think the floor is that you could, if it stays as is enabling that you can do it. I think there may have to be a quote unquote ceiling as it relates to what is included when we talk about tenant holding over. So I just wanted to make that point.
Yeah, and to piggyback on that as well, I know that on the occasions where I have to go to court, every jurisdiction is different, and sometimes it drives me crazy too. So I'm sure it drives everybody else nuts as well. Delegate Lehman.
Thank you, Mr. Chair. And just very briefly, because it is almost 9 o'clock. So somebody much smarter than me sent me an example of a contract situation under Maryland law to answer Delegate Nowraki's question. Under Maryland law, an insurance carrier cannot cancel your coverage without cause. And so, you know, for people who have health insurance, I think any of us would be pretty angry if a carrier just said, hey, you know what, we're just not going to renew your policy for no reason at all. We're just not going to. They can't do that. So, Delegate Nowraki, there's your answer. There's at least one example of where that's not allowed.
Could you send that to us, Delegate Lehman?
Sure. Yeah.
Yeah.
Mr. Chair, if I may, Delegate Lehman, my one question to that would be, is those are typically not term contracts there, right? I mean, your life and your health insurance not set to a specific term. I think that's the distinction there between this. There's a defined time period here with this. Health insurance is however long you're alive, theoretically. I guess that's a term in a sense, but
yeah, I'm talking about health and not life insurance. But
I'm talking about health too. There's not necessarily a term there of time. There, you know, it's
right.
I think that's a key difference here. You know, between that type of policy versus what I'm talking about here, where you have a defined period of time.
Yeah.
I mean, a health insurance policy doesn't last forever and ever. It's, you know, depending on the, you know, how you're acquiring it. If it's through your employer, it gets renewed, and employers, you know, change companies and change the terms, but it's a period of time where you either opt in or opt out. So I do think it's similar in that sense. But anyway,
I think what Delegate Nowraki is saying, let's take that example of insurance. Let's take that insurance example. If you purchase insurance, you don't buy the insurance for 12 months.
Right.
You buy the insurance and you continue to pay. And as long as, in most cases, as long as you pay the premium, you are still going to be insured. I recall many years ago, I had a passed piece of legislation that said for homeowners insurance, you could not be canceled for an inquiry. And it took me 3 years to get it done because there was no definition of the word inquiry, but that's a different topic. But I think what Delegate Nowraki is talking about, the lease is for a 12-month time period, whereas the insurance is not a specific time period on that insurance.
Yeah, yes, sir. Mr. Chair, that's exactly what I'm referring
well,
to.
I'll dig into the law further. I think you could say that there would be similar analogies with other types of insurance, with auto and other types of insurance. But I'll be happy to do a little digging.
Yeah.
I just wanted to bring that up.
I do appreciate it. I do appreciate the input. And as I indicated previously, I would encourage everyone else who's listening, because I know we've got a lot of people on the call here. I'm asking that everyone listening, in terms of not only Delegate Nowraki's question, but all the other questions that we have proposed during this discussion, I would like to have every other person that is listening to send us something to help us make some decisions on this piece of legislation. Ben, did you want to add something?
I can't. I was going to add something, but Delegate Baker could certainly go as well.
Delegate Baker?
Well, yes. The first thing I'd like for Ben, if possible, to provide us with statutes that deal with retaliatory evictions. If you could provide that to us.
In other words, if I could rephrase that, let us, Ben, if you could give us some definitions of what is retaliatory and how that affects an eviction process. What is retaliatory?
Yeah, anything that would be helpful for us.
Yes.
And the other thing is, back to Ms. Lehman, she said she was going to do some research. I do think that if an insurance company or a health insurance company wants to discontinue your coverage, I would like to know what length of time, 3 months, 2 months, how much notice would they have to provide to you before they could terminate your insurance, both car and health?
I will absolutely ask that question. I will use my secret tool, which is the legislative library for the General Assembly. They're free and they're quite accurate. Thank you, Mr. Chair. Thank you, Delegate Baker.
Thank you.
Don't give away all your secrets there, Delegate Lehman. Ben, you wanted to add something? Discussion, please? Please do.
Yeah, thank you, Mr. Chair. Maybe one thing I could do, you know, depending on your preference, I could go over. It sounded like there was some interest or some consensus about redefining what substantial breach means, or just having this as a breach of a lease. You know, that's something, you know, for next week we can have amendment on that. And people can let me know if they're thinking something different about
Okay.
the general. Oh,
If I could, I'm sorry, Mr. Chair.
Go ahead, Delegate
I
Lehman.
just, if Ben is going to do that, I think that one of the issues is that all the tenants be treated the same, so that you don't just use a pretense of like some minor breach for one person and the next door neighbor is doing the exact same thing, and they leave them alone. If you're, you know, I think, I don't know if there's a legal challenge to that. I think, do you have to treat all your tenants the same or not, is the question. I mean, this is like a civil rights question almost, you know. I mean, you should, if you have two neighbors who are doing the same thing, they both smoke and it's a no smoking building, but you know, cancel the contract of one of them and make them leave, but the other one stays and continues the same behavior. That's kind of like, that's one of the issues I think we're trying to get at, is that people are not treated unfairly, that there's some kind of balance. If you're going to enforce something, you should enforce it across the board, whatever the lease says, or not.
And I agree with what you're saying, Delegate Lehman. Everyone needs to be treated fairly and the same. Yes.
okay. So I'll, you know, based on the subcommittee's helpful feedback, we could do an amendment on that. It sounded like there's some consensus or general interest on making it statewide bill without having the issue of that the judiciary had raised about multiple or 24 different types of just cause in each county. So that's like, depending on what the chair wants, you know, that's something we could get an amendment to make it a statewide bill that, you know, codifies this in the same way that we have with the current holdover statute in 8402, but it's.
Sorry.
Go ahead, Delegate Healy.
I'm sorry. I just thought, it just occurred to me that if maybe we could have a statewide standard and then there could be a local opt-in, opt-out.
And I think on that particular topic, I think that was the primary objective for this just cause legislation in front of us. But I'll let Ben kind of go through his magic penmanship and work that out. Ben, do you want to say something?
Yes, and just to clarify, it's going to be a statewide standard, but then the counties can opt out of it.
I think that was one of the suggestions.
That sounds similar to kind of what we have at this time. But yeah, I can look at that. I could go through a couple more things, Chair Holmes or Delegate Lehman, if they want.
Delegate Lehman?
Just really briefly, enabling is opting in. I don't think we want to talk about opting out. I don't think politically this will pass as a statewide bill. That sounds like a poison. I would characterize that. I don't think anyone intends to do this. That would be like a poison pen amendment. I don't, we should not even go there. That's not politically, that is not going to fly. I understand establishing a, to Delegate Boyce's point about the shall versus may and that list of 6 things. Whether we want to set a more clear floor and say they shall do at least, any local jurisdiction that adopts this through enabling legislation takes this up, must do these 1 or 2 things, and they may do anything else they, would like to, whatever they deem fit. But we're not. I respectfully, we are a separate and co-equal branch to the Maryland, court system. And I understand, the concerns of the district court system, and I respect that, but we're lawmakers. And so, we have to do what we think is right for the, constituents of the state of Maryland. And then the courts, it might be challenging for them, but they're going to have to deal with it if we do it this way. So that's all I have to say, Mr. Chair.
Okay. So maybe then, based upon Delegate Lehman's discussion, if we did in fact, like my grandfather used to tell me, get more specific in your specificity.
It's pretty specific. I think this would doom the bill. I'm saying it as nicely as I can. Thank you.
Exact ground level for what each municipality should do if they adopt this, then that might satisfy that Delegate Lehman's point. Delegate Allen?
Thank you, Mr. Chair. No, I just wanted to agree with everything Delegate Lehman said pretty much. I could not agree more that I think this would doom the bill, especially on the floor of the House. And I also want to add, like she said, we are a co-equal branch with the judiciary. And there's 24 different standards for speed cameras right now that we have to deal with in our committee all the time. And respectfully to the judiciary, I think they could deal with a handful of jurisdictions choosing to enact legislation that we are enabling them to enact. We have enabling legislation all the time, and to me, this is a bit of a straw man argument they're arguing here.
Is that kind of like Sunday hunting, Delegate Allen?
Exactly.
Different topic. I won't go there. Delegate Baker.
Yes, this will be my last comment.
Oh, and it doesn't have to be Delegate Baker.
It will be. I know everybody's tired and they want to get out of here. And I just hold on. I want to thank Delegate Delegate Lehman for her great comments, her institutional knowledge with some of the comments and recommendations she's made here. And I want to thank her for that. I can just tell you, I don't know how this bill can be fixed. I just don't think it's possible. And I'm not trying to be negative and I'm not trying to be mean, but I just think it's a bad bill. And with that, that's my last comment for the evening. And thank you for letting me participate.
Certainly. You don't have to leave. Thank you, Delegate Baker. Ben, you have the floor.
Okay, thank you, Mr. Chair. And just to keep it on track, and so that we have kind of like an action plan, or we're ready to go for next week with voting, because I know we have some other big bills moving as well.
Really?
Yeah. So another one, we'll get an amendment on having just cause shall include 1 through 6, if my understanding is correct from what the subcommittee was saying. And then we can also add another provision that, so just cause has to be these 1 through 6. And then in addition to that, the county can have an additional just cause grounds as well. Does that sound like another option to move forward with, Mr. Chair?
I think that was, in fact, what was discussed. Yes. And again, as we go through these, as other persons are listening in, I'm encouraging you to send in your emails so that we can address those as well. But you are correct, Ben.
Okay, and then I think the last couple of things in line with that, Mr. Chair, was just if people want other types of just cause in general, you know, those could be certainly considered as amendments by the subcommittee from a sponsor that we have. So that's one additional thing to note. And then, you know, or removing just cause grounds. So.
Yeah, we'll gather all this information and we'll get back to this additional discussion next week. Delegate Rocky.
Mr. Chair, I just want to add, I'm having so much fun. I'm going to order some pizza, and I wanted to see maybe if we all just want to stay around all night long and just have fun and to have a debate all night, or maybe some Chinese food. Whatever.
Listen, if you're buying, I'm for it.
I think I'm going to, well, anyway, ladies and gentlemen, we've had a very good discussion. And I really appreciate, like I said, all of the open-minded discussion and how we think we could work through this piece of legislation and all the other pieces of legislation as well. Because that is what we are assigned to do here by us being elected to this position. We will have a continued discussion on this bill and a couple other ones as well. And unless is there any other discussion before I adjourn the meeting? Seeing none, ladies and gentlemen, I sincerely do appreciate the discussion and all of your suggestions, and we'll try to get this thing taken care of as soon as possible. Have a great evening and be safe out there.
Rocky, I want my pizza.
I want Smith Island cake.
I'm working on it.